Доброго дня усім гостям, усім, хто нас...
Good afternoon, everyone. The next briefing about the attack on Judge Golnik. Will this case be solved? Our guests are Larysa, Golnik, the judge of the Oktyabrskiy district court from Poltava, Ihor Havrylenko, blogger, Yevhen Hrushovets, the partner of law firm Ario, Ukrainian Bar Association member, Kateryna Ryzhenko, legal advisor at Transparency International Ukraine, and we wait for Roman Maselka, member of the Public Council for Integrity. Welcome. Good afternoon, everyone. On the 22nd of November 2017, there was a crime committed against me. Everything happened in a banal manner. It was like hooliganism. I was returning home in the evening together with Ihor Havrylenko, my husband, and while passing the park near the court, this is the center of Poltava city, two young men in black, in hoods with hidden faces, with batons, they attacked me, and my husband tried to prevent this attack, and because of this, I avoided those bodily harm that were intended against me. 4.5 months passed, and I would like to draw your attention why this banality is present. They were on bikes, and we wanted to detain these young people, and we got evidence, physical evidence, to bikes. They were not able to leave using these bikes. And after we informed about this crime, these young people, they fled. We were not able to detain them, and people who were passing by in the park, they were not able to respond, maybe because of the character, or they were threatened, and in this way these guys prevented being caught and fled. And here there is a way on the slide, and they escaped through this way, and the operative group that came to the crime scene, they followed this way, and we see that this is marked in red, this path. In one place there are many turns, and the attackers knew this locality well, and we see here that maybe they were helped by someone with the car, because their way is stopped in one place. 4.5 months passed. So whether they were found at this time, no, they were not caught, but a lot of work has been done by investigators, all material evidence, bikes, the examinations, the tests were made, everything possible was done. And I would like to ask the lawyer, the representative of Association of Ukrainian, the member of the Bar Association. I would like to ask my colleague to tell us whether everything was done in the proper way. First, good afternoon. I would like to tell you about legal components of those events that happened on the 22nd of November, maybe before this, and also about how pre-trial investigation is going on. Before Larysa was attacked on the 22nd of November, there was after she was attacked, the case on hooliganism, the Article 296, was introduced in the register, and we see that there were certain objects, the batons, the sticks, were used by attackers. They were used to produce bodily harm. Larysa, after the data was introduced into the register, she was called on as a witness, and criminal proceedings were started. But as of now, the investigation didn't find the guilty, and whether these people are established, no, and this case should be investigated at once. If the criminals are not established at once and people are not detained, those who helped to commit these crimes, there is high probability that this crime won't be solved. And I would like to say that this is a heavy crime. And this can produce up to 5 years in prison, and why this crime was committed, and whether it was committed against Golnik as against the citizen or against her as a judge, because she prevented some actions. So investigative bodies, they should have investigated the motive, and maybe this crime was committed because Larysa is a judge, she has a status of a judge. Maybe she prevented someone from some actions, and maybe those criminals, those two people on bikes, maybe they were not interested in this crime, but they may have committed this crime because they were promised some remuneration for this, to prevent Larysa from some actions that she is doing now. So she was summoned as a witness, and she provided she provided evidence, and also the material evidence were provided, the bikes from the scene, and samples were taken, and also there was a hat that was used by the attacker to hide his activity, to reduce the risk that they will be identified. And this component of criminal proceedings concerning material carriers and other carriers, this is exhausted, and whether it is possible to get new evidence. The character of this crime does not allow to get new evidence in 4 or 5 months.
Whether this pre-trial investigation was relevantly conducted at the level of investigators who are conducting this pre-trial investigation, they seem to be interested in finding the assaulters and the organizers, but whether the law enforcement structure, such as the prosecutor's office of Poltava region, which in the criminal procedure, according to the code of criminal procedure, is the highest, is the top level body, whether it is interested in providing more resources, more inputs to make this proceedings principled one. We should answer whether the law enforcement system defend the citizens of Ukraine who became the objects of criminal violations, and those people who have special status, such as judges, whether they are protected. Using the case of Larysa Golnik, we can say that no judge, not only in Kyiv, Poltava, in any city or town who is competent in taking certain decisions, certain judgments, he or she cannot feel safe if the judgment he or she takes would be to the benefit of some party. This judge can be subject to impact, not physical impact mandatorily, but maybe psychological impact. They are made to take decisions which are needed. The conditions in Ukraine are so where the judge cannot take any other decision, any integral decision, integrated decision. The case in which Ms. Golnik is a victim, whether we believe that the criminals would be identified and detained. We think that with every day, as the time goes, our belief that they will be detained becomes lower. Using the example of Mrs. Larysa Golnik, we cannot say that judges could be protected in Ukraine, could feel protected in Ukraine, and we do not see that prosecutors make all inputs into investigating such cases. And we are also concerned with the situation where we know that Ms. Larysa could be a figure in some other criminal proceedings where she is not a victim, because we know that the prosecutor's office of Poltava region conducts criminal proceedings management where Ms. Larysa Golnik is claimed to disclose some information to some bodies where she is blamed in providing false information, this way trying to create the environment where the proceedings would not be conducted correctly. So there are many criminal proceedings where she is accused without the grounds. This prosecutor's office could not be named unbiased and integral if such criminal proceedings have been started, have been initiated by such a prosecutor's office against Ms. Golnik. If in this category of crimes no criminals are identified in 1 year, such criminal proceedings should be closed. Our criminal proceedings do not fall into this regulation because the amendments were included after our case was initiated, but anyway in a year it would be closed. And when there is no criminals punished, this situation would encourage other criminals to commit crimes. So I cannot exclude that those criminals who were not found and identified, they are now committing some other crimes, and we cannot exclude that Ms. Golnik would become the victim of the crime of the same criminals again. And when the country is so corrupt, we have the situation where judges are under pressure, where corrupt links are so common. So people understand that the system do not protect them. If the citizen of the country understand that witnesses are always under pressure, this case may become the resonant case, and the citizens will see that Ms. Golnik was suited against. The only high quality result in this case may be if the criminals are detected and punished. The goal is not to jail the criminals, but the goal is to demonstrate first that our system is capable of investigating the cases, and second, to demonstrate to the citizens of Ukraine that they can become witnesses, they can witness, and the cases are investigated in a correct way. And the third is that people should believe they are protected by the law enforcement and judicial systems of Ukraine. So we will be waiting for integral, impartial investigation, and soon we will see the results of the investigation. I would like to add why I believe that this crime was conducted against me, and why I believe that this case was this crime was committed by some order of some customer. Those people, they were waiting in a special place. They knew my usual route which I use, and I use it every day when I go back home. Moreover, as I have already said, when they escaped, the sticks were not found. So it was something which could be very fast hidden, something like telescopic sticks, which could easily be hidden by criminals. So it was an intentional assault. Here you can see potential clients, customers of this crime who might wanted my activities to be stopped. We see their names: Strukov, Mamayev, Kavzhoga. Alexander Strukov was the head of the court where I am a member of staff, which is the place of my job. Disciplinary proceedings against him will be heard tomorrow, and his fate as a judge would be defined tomorrow. He was interested in preventing my active operations, my active anti-corruption actions. Why? I believe this is the instigated crime.
Instigated замовник.
I was the person who reported the crime once this crime was heard in one of the courts in Poltava city, and the proceedings are at the final stage, but the case against the mayor of Poltava and the other persons who could be accomplices in this crime. I know that in August 2017 the detectives of National Anti-Corruption Bureau prepared the charges which were not signed by the Special Anti-Corruption Prosecutor's Office. So far I do not know the results of pretrial investigations in the case against the mayor of Poltava, and this criminal proceedings is still at the stage of pretrial investigation. So for 3 years, people, when they see that the crimes are not punished, this provokes new crimes. I would like to give the floor to my husband, who will tell you what happened in follow-up of the assault against me, and why we think the prosecutor's office of Poltava did not do relevant actions, adequate actions to investigate this case. My name is Ihor Havrylenko. I am a husband of Judge Golnik, and at the same time I am an investigative journalist. I would like to comment on this slide. We see Mr. Strukov, Mamayev, and Kavzhoga. Strukov is the head of district court where Judge Golnik is working. Mamayev is a prosecutor, and when Golnik heard the case against Mr. Mamayev, Kavzhoga was a representative of him in court. He was not a lawyer those days. He has just recently received the lawyer's certificate in Donetsk region. He is assigned to Kramatorsk town, which is very surprising fact, demonstrating that this person is capable of using the laws to his benefit. Kavzhoga is deputy head of Poltava law enforcement police office. He received a bribe for racketeering his subordinate and for being an accomplice in a drug dealing scandal. Then he returned to his place, and now he is a veteran of law enforcement system. As to the regional prosecutor's office activities in the case of the judge of Golnik, here we see the stand-up prosecutor's office. We see that the request of investigator to take information by phone calls before the attack, and at the moment of attack it was sent on November 28th, but the permit the investigator received only in a month. In the first days after the attack, Larysa, Golnik and me, we said that if the request of investigators will be filed to Oktyabrskiy court, to his head Strukov, who is in close relations with Alexander Kovzhoga I mentioned before, and if the surveillance over the investigation will become conducted by the regional prosecutor's office, the result would be bad. So the slide demonstrates delays in the proceedings in the investigations when 15 to 23 days the requests remained untried, unconsidered, so the investigative actions were not fast. And we know that during this time from November 22, not so long time have passed, but the prosecutor's office of Poltava region did not conduct procedural oversight over the case. The regional prosecutor's office saying that this case is resonant. It requested several times all materials of the case, and for 35 days the case was kept by the regional prosecutor's office. For some reason the investigators were considering those materials. I would like to say also that the investigation did not pay attention to some facts, although we mentioned them. You can see one person on this photo. This person is under the influence of Mr. Strukov because his son received very loyal punishment, very short term of punishment, so he is a person under the influence of Mr. Kovzhoga. So in November, his car was seen. The persons were in the car when and they tried to hide their faces, those persons who were in his car. After this event, we received information from law enforcement officers and from acquaintances and people who we even didn't know. We got information, for example, from one journalist who was covering the activities of the Judge Strukov, who very often violated the rights of journalists during sittings. He can sleep during trials, and this journalist was proactively writing about the Judge Strukov, so he also became the victim of persecutions. His house near Poltava was attempted to be set on fire. Thanks to his neighbors, the car was the plate number of the car in which those persons, those criminals tried to escape. This car brought investigators to Mr. Kovzhoga. So there is a trace to Mr. Kovzhoga. So Kovzhoga made the same actions those times. He also filed many filed many cases against that person, just as against Mr. Golnik, and he also became the victim of the attack. He didn't see faces of his assaulters, so we insistently were asking the investigators to take the information about telephone calls on all those facts of persecuting us and that person. In that case, what is happening in the prosecutor's office, which from November last year lost the chances? During several months against Golnik, Judge 6 proceedings were initiated, and this is to add to other criminal proceedings. Larysa and me, we as if as if we took the garage from our neighbor. Also, in fact, we bought that garage. But now we have the criminal proceedings against others. We are a criminal group who appropriated this garage. In this case, the Judge Strukov said that Ms. Golnik is not the victim. Kateryna lawyer, who has been closely cooperating with Mr. Kovzhoga, he filed a request that Golnik falsified the evidences in the case against Strukov. And as if there were two independent judges in this case, so the witnesses, they started to look for the witnesses. This is the letter of the witness who provided the evidence that there were very loud cries in the office of this judge, and this woman could not be found now. The district police officer, he was provided inputs, money for finding this witness. Also, she reported that she is in a hospital and she can't go to the court, but her relatives were under pressure, and she came to interrogation without even getting a written summon. The summon was provided not to her but to her son, and in follow-up of the interrogation, but not before the interrogation. Within 1 day, within 4 days, the case so fast was returned from Oktyabrskiy court to the Court of Appeals. So it was the request of the procedural prosecutor. For 3 years, all phone calls of this woman for 3 years were investigated. So the case was falsified very fast, so it is very well understandable who was interested in the attack on the Judge Golnik.
I give the floor to Kateryna. Ryzhenko. A lot of organizations support me, and I thank NGOs and to individuals who support me, because without the support it is really hard to do with such things, and there are a lot of emotional efforts, and I'm really grateful for support that I am provided with. Thank you, Larysa. People in the world are brought up that they should be able to speak openly about crimes and crimes connected with corruption, and we only recently started this process, and such people as Larysa, they are pioneers in this cases, people who fight against corruption in this country, and the culture of fighting corruption in Ukraine, it is still at the low level in our country, and such people as Larysa, they are in the risk zone, and they become the targets as well as the members of their families, and they are under pressure and actions of people who committed these corruption crimes. And we heard about these cases from Larysa and from her husband and other people. And fight with corruption in the country depends on the inside information that can be provided by whistleblowers. Without this information, it is impossible to clear Ukraine from corrupt officials, and they should be supported reported by law enforcement bodies and the media, but we face the situation when criminal cases are started against them and physical attacks on whistleblowers and the members of their families. And the case of Larysa, she has more possibilities to protect her rights because she is a part of this legal system, but the majority of citizens who are witnesses in corruption crimes, they do not understand where they should go, what should they do. And the case of Larysa, in civilized country, this should be an example how to protect the rights of whistleblowers and how these corruption crimes should be properly reported, and the state should provide protection to such whistleblowers as Larysa. And we heard about capability of or lack of capability of law enforcers and court systems, but also there should be public awareness about these cases, and society should condemn corrupt individuals. And our NGO, together with other organizations and whistleblowers who are courageous enough to speak openly about corruption, they really face risk when they provide such information. Such people should be supported by the journalists and other activists and people with active social position. And there should be proper understanding that this case is of interest, and if the law enforcement system is not able to protect such people, the corrupt people should see that society is interested in the case, and the society demands from the law enforcers and the state that these cases should be properly dealt with. And Transparency International Ukraine, we believe that the state of Ukraine should continue reform of law enforcement and judiciary, and the trust to legal system is 5%, as surveys show, and the whistleblowing about the corruption, this should be incentive for reform in the judiciary system and in the system of courts, and people should get protection from their employers and from the state and from the civil society and citizens of Ukraine. And there should be mechanisms created that would prevent persecution of such whistleblowers of corruption cases at their workplace and in daily life. And there are some norms in the legislation, but they should be not declarative. They should be implemented. And Larysa and lawyers who help her, they know how to use these mechanisms, and they should be provided with the opportunity to yield results. And the end aim of this awareness of society, this our society should not tolerate corruption crimes, and our society should have zero tolerance to corruption. And we believe that the legal system, the judiciary, they should be involved actively in this process. What about the number of cases that are opened against you? So I'm not ready to answer. There were 6 cases, and before this there were 2 cases. maybe there were some cases were closed. The situation changes constantly. For example, according to claim of Kavzhoga, criminal proceedings were started concerning bribing, and NABU carried out investigation on the 29th of December, but it was closed. This case was closed. Kavzhoga appealed, and on the 2nd of April, the Solomynsky court judge rejected the claim of Kavzhoga, and the provision of whether this document will be appealed against, we do not know. So the situation is changing. Do you have questions, dear colleagues? If there are no questions, maybe people will speak with you off records. Thank you. We will hope for a fair decision. Thank you. Thank you for coming.